Question 1. Analysis of a scenario where a resident of Oklahoma, who holds a valid Oklahoma handgun license, wishes to obtain a Texas license to carry a handgun. This individual has completed a handgun proficiency course in Oklahoma that is recognized by Oklahoma law. What is the most appropriate course of action for this individual to obtain a Texas LTC, considering Texas Government Code Section 411, 173 and related provisions? Option A. The individual should contact their local law enforcement agency in Oklahoma to inquire about the process for obtaining a Texas license to carry a handgun, as they are an Oklahoma resident. Option B. The individual must apply directly to the Texas Department of Public Safety, DPS, for a Texas license to carry a handgun, ensuring they meet all Texas eligibility requirements, including completing a handgun proficiency course that meets Texas standards and submitting the required application and supporting documentation to the Texas DPS. Option C. The individual should only focus on meeting the requirements of Oklahoma law, as their existing license from their home state should be sufficient for carrying in Texas due to reciprocity. Option D. The individual can assume their Oklahoma handgun license is automatically recognized in Texas for carrying purposes and does not need to apply for a separate Texas license to carry a handgun. Correct answer is B. The individual must apply directly to the Texas Department of Public Safety, DPS, for a Texas license to carry a handgun, ensuring they meet all Texas eligibility requirements, including completing a handgun proficiency course that meets Texas standards and submitting the required application and supporting documentation to the Texas DPS. Explanation: this scenario is professionally challenging because it requires a non-resident applicant to navigate the specific requirements for obtaining a Texas license to carry a handgun, LTC, while residing in another state. The core of the challenge lies in understanding and correctly applying Texas law to an individual who is not a Texas resident, ensuring compliance with all statutory prerequisites. Careful judgment is required to avoid misinterpreting or overlooking the nuances of Texas's reciprocity agreements and the specific training and application procedures mandated for non-residents. The correct approach involves the applicant diligently researching and adhering to the Texas Department of Public Safety's, DPS, specific guidelines for non-resident LTC applications. This includes understanding that Texas law, under Government Code Section 411, 173, allows non-residents to obtain an LTC if they meet certain criteria, including being at least 21 years old, not being disqualified by law, and completing a handgun proficiency course that meets Texas standards. The applicant must also ensure their home state's laws do not prohibit them from carrying a handgun, and that their home state has a reciprocity agreement with Texas or recognizes Texas LTCs. The application process itself, including submitting fingerprints and the required documentation to the Texas DPS, must be followed precisely as outlined by Texas law. This approach is correct because it directly addresses the statutory requirements for non-residents seeking a Texas LTC, ensuring full compliance with Texas Government Code. An incorrect approach would be for the applicant to assume that their current handgun license from their home state automatically grants them the same rights and privileges in Texas without further application or verification. This fails to acknowledge that Texas has its own licensing scheme and specific requirements for non-residents, even if reciprocity exists. Texas law requires a formal application process for non-residents to obtain a Texas LTC, and simply possessing a license from another state does not bypass this. Another incorrect approach would be for the applicant to rely solely on general information about handgun carry laws without consulting the official Texas DPS resources or Texas Government Code. This could lead to misunderstandings about eligibility, training requirements, or the application process, potentially resulting in a denied application or unintentional violation of Texas law. A further incorrect approach would be for the applicant to believe that they only need to meet the requirements of their home state's handgun laws. While their home state's laws are important, Texas law governs who can carry a handgun within its borders, and non-residents must satisfy Texas's specific criteria for obtaining an LTC. The professional decision-making process for similar situations should involve a thorough review of the relevant state statutes and administrative rules governing the specific license or permit. Professionals should prioritize consulting official government sources, such as State Department websites or legislative codes, to ensure accuracy. When dealing with cross-jurisdictional issues, it is crucial to understand the specific requirements of each relevant jurisdiction and any applicable reciprocity agreements or lack thereof. A systematic approach, starting with understanding the applicant's current status, and then meticulously addressing the requirements of the target jurisdiction, is essential to avoid errors and ensure compliance. Question 2. Consider a scenario where a resident of Oklahoma who currently holds a valid Oklahoma handgun license is applying for a Texas non-resident license to carry a handgun. During the application process, they are asked to provide information about their handgun licensing status in their home state. What is the most appropriate action for this applicant to take? Option A. Assume that since Texas has reciprocity with Oklahoma, their Oklahoma license status is not a required detail for the Texas application. Option B. Submit a copy of their expired Oklahoma handgun license as it demonstrates prior licensure. Option C. Accurately report that they possess a valid Oklahoma handgun license, providing the necessary details as requested on the application. Option D. State that they do not possess a handgun license in their home state as they are applying for a Texas license. The correct answer is C. Accurately report that they possess a valid Oklahoma handgun license, providing the necessary details as requested on the application. Explanation. This scenario is professionally challenging because it requires the applicant to navigate the specific requirements for obtaining a Texas non-resident license to carry a handgun, particularly concerning their home state's licensing status and the reciprocity agreements between Texas and their state of residence. Misunderstanding or misrepresenting this information can lead to denial of the application, potential legal repercussions, and a failure to adhere to the Texas Department of Public Safety's DPS regulations. Careful judgment is required to ensure all submitted documentation accurately reflects the applicant's qualifications and compliance with Texas law. The best professional practice involves accurately reporting the status of their handgun license in their home state. This approach is correct because Texas Government Code Section 411-173 requires an applicant for a non-resident license to carry a handgun to be a legal resident of another state and to be licensed by their home state to carry a handgun. Providing truthful and complete information about their home state license status directly addresses this statutory requirement. It demonstrates an understanding of and adherence to the specific eligibility criteria set forth by the Texas DPS for non-residents. An approach that involves stating they do not possess a handgun license in their home state, despite holding one, is incorrect. This constitutes a misrepresentation of material facts to a state agency, which violates the spirit and letter of Texas Government Code Section 411-173 and could be considered a false statement on an official application, potentially leading to penalties. Another incorrect approach is to assume that because Texas has a reciprocity agreement with their home state license status is irrelevant. This is flawed because Texas Government Code Section 411-173 explicitly requires proof of being licensed in their home state as a prerequisite for a Texas non-resident license. Reciprocity allows Texas to recognize the validity of a license from another state, but it does not waive the initial requirement for the applicant to possess such a license from their home state. Finally, an approach that involves submitting an expired home state license without noting its expired status is also incorrect. While Texas may have reciprocity with the home state, the applicant must be currently licensed. Submitting an expired license implies they are currently licensed, which is factually inaccurate and fails to meet the ongoing eligibility requirements of Texas Government Code Section 411-173. Professionals should approach such situations by thoroughly reviewing the specific eligibility requirements for the Texas non-resident license to carry a handgun, paying close attention to the statutory mandates regarding home state licensing. They should then gather all necessary documentation from their home state that proves current licensure and accurately report this information on the Texas application. When in doubt, consulting the official Texas DPS website or contacting them directly for clarification is the most prudent course of action. Question 3. During the evaluation of an application for a Texas license to carry a handgun, a certified instructor in Texas is presented with documentation from an applicant who is a resident of Oklahoma and claims to have completed a handgun proficiency course in their home state. The instructor must determine if this out-of-state training is sufficient to issue the required Texas certificate of training. Which of the following actions best reflects the instructor's professional and legal obligations under Texas law? Option A. The instructor should issue the Texas certificate of training based on the applicant's sworn statement that they completed a comprehensive handgun course in Oklahoma without further verification. Option B. The instructor should accept the Oklahoma training certificate at face value, assuming that any state-approved handgun proficiency course is equivalent to Texas requirements. Option C. The instructor should inform the applicant that Texas law only recognizes handgun proficiency training completed by instructors certified in Texas, and therefore the Oklahoma training cannot be accepted. Option D. The instructor should request a detailed syllabus and proof of the Oklahoma instructor's certification to verify that the training covered the same substantive topics and met the same proficiency standards as required by Texas law for a license to carry. The correct answer is D. The instructor should request a detailed syllabus and proof of the Oklahoma instructor's certification to verify that the training covered the same substantive topics and met the same proficiency standards as required by Texas law for a license to carry. Explanation. This scenario presents a professional challenge because it requires a licensed instructor to navigate the complexities of Texas law regarding handgun carry by non-residents, specifically concerning the validity of training received outside of Texas. The instructor must ensure that any training they recognize for the purpose of issuing a certificate of training for a Texas license to carry a handgun meets the specific requirements set forth by Texas law, even if the applicant is a non-resident. Misinterpreting these requirements could lead to the issuance of invalid certificates, potentially jeopardizing the applicant's ability to obtain a license and exposing the instructor to regulatory scrutiny. The correct approach involves verifying that the applicant's out-of-state training meets the substantive requirements for handgun proficiency as mandated by the Texas Government Code, Chapter 411, Subchapter H. This means the training must cover the required topics, including handgun use and safety, nonviolent dispute resolution, and the laws regarding the use of deadly force. The instructor must be able to confirm that the out-of-state program provided instruction equivalent to that required for Texas residents. This is the best professional practice because it directly adheres to the spirit and letter of Texas law, ensuring that only individuals who have received demonstrably equivalent training are certified. An incorrect approach would be to assume that any handgun proficiency training completed in another state is automatically sufficient for a Texas license to carry. This fails to acknowledge that Texas law specifies the content and nature of the required training, and out-of-state programs may not cover these specific elements. Another incorrect approach is to issue a certificate based solely on the applicant's assertion that they completed a course, without any independent verification of the course content or the instructor's qualifications in the other state. This bypasses the instructor's responsibility to ensure compliance with Texas regulations. Finally, refusing to recognize any out-of-state training, regardless of its content, would be overly restrictive and not in line with the law's intent to allow for equivalent training. Professionals should employ a decision-making framework that prioritizes regulatory compliance. This involves thoroughly understanding the specific requirements of the Texas Government Code, Chapter 411, Subchapter H, regarding handgun proficiency training for a license to carry. When presented with out-of-state training, the professional must actively seek to verify that the training curriculum and delivery method are substantially equivalent to Texas standards. This may involve requesting course syllabi, instructor credentials, or other documentation from the applicant. If such verification is not possible or the training is demonstrably deficient, the professional must decline to issue a certificate of training and clearly explain the specific Texas legal requirements that were not met. Question 4. Research into the requirements for a Texas license to carry a handgun reveals that a qualified instructor is approached by an individual who is a resident of Oklahoma and wishes to obtain a Texas LTC. The individual states they have a valid Oklahoma handgun license and are legally permitted to carry a handgun in Oklahoma. What is the most appropriate course of action for the Texas LTC instructor? Option A. Conduct the firearm proficiency training but defer the verification of legal eligibility for the Texas LTC to the Texas Department of Public Safety upon application submission. Option B. Inform the applicant that only Texas residents can obtain a Texas LTC and therefore they cannot proceed with the instruction. Option C. Proceed with the instruction, assuming that because the applicant has a valid Oklahoma handgun license and resides in a state with reciprocity with Texas, they automatically meet all requirements for a Texas LTC. Option D. Verify the applicant's eligibility for a Texas LTC as a non-resident by confirming they meet Texas residency requirements for non-residents, are legally permitted to possess a handgun under federal and Texas law, and that their Oklahoma license, if applicable, is valid and recognized under Texas law for the purpose of obtaining a Texas LTC. The correct answer is D. Verify the applicant's eligibility for a Texas LTC as a non-resident by confirming they meet Texas residency requirements for non-residents, are legally permitted to possess a handgun under federal and Texas law, and that their Oklahoma license, if applicable, is valid and recognized under Texas law for the purpose of obtaining a Texas LTC. Explanation: this scenario presents a professional challenge because it requires a licensed instructor to navigate the nuances of Texas law regarding the carrying of handguns by non-residents, specifically when the instruction occurs within Texas borders. The instructor must ensure compliance with Texas Government Code Chapter 411, Subchapter H, which governs the license to carry a handgun, LTC. A critical aspect is understanding the reciprocity agreements and the specific requirements for non-residents seeking instruction that could lead to a Texas LTC, even if they do not reside in Texas. The instructor's responsibility extends beyond simply teaching firearm safety. It involves ensuring the student meets the eligibility criteria for a Texas LTC, which includes understanding the implications of their non-resident status. The correct approach involves verifying the applicant's eligibility for a Texas LTC as a non-resident, which includes confirming they meet the residency requirements as defined by Texas law for non-residents seeking an LTC, and that they are not disqualified for any other reason. This means the instructor must be knowledgeable about the specific provisions in Texas Government Code Section 411, 172, and Section 411, 173 that outline who is eligible for an LTC, including the conditions under which a non-resident can obtain one. The instructor should confirm the applicant possesses a valid handgun license from their home state, if applicable, or meets the equivalent requirements to carry a handgun in their home state, and that they are legally permitted to possess a handgun under both federal and Texas law. This ensures the instruction is provided to someone who can legally obtain a Texas LTC, thereby upholding the integrity of the licensing process and preventing potential legal ramifications for both the instructor and the student. An incorrect approach would be to proceed with instruction without thoroughly verifying the non-resident applicant's eligibility for a Texas LTC. This could involve assuming that because the applicant is from a state with reciprocity, they automatically qualify for Texas instruction. This fails to account for the specific Texas statutory requirements for non-residents, which may differ from reciprocity agreements. Another incorrect approach would be to provide instruction without confirming the applicant's legal right to possess a handgun in Texas, potentially overlooking federal disqualifiers or specific Texas prohibitions. This demonstrates a lack of due diligence and a failure to adhere to the instructor's ethical and legal obligations to ensure the student is a lawful candidate for licensing. Professional reasoning in such situations requires a proactive and diligent approach. Professionals should always consult the most current Texas statutes and administrative rules pertaining to the license to carry a handgun. When dealing with non-residents, it is imperative to specifically research the provisions related to non-resident eligibility and any applicable reciprocity nuances. If there is any doubt about a candidate's eligibility, the professional should err on the side of caution and seek clarification from the Texas Department of Public Safety or legal counsel before proceeding with instruction. This commitment to thorough verification protects the professional, the student, and the integrity of the licensing system. Question 5. Governance review demonstrates that a Texas resident, Mr. Silas, who holds a valid Texas license to carry a handgun, LTC, has recently moved to Oklahoma and is seeking to continue carrying a handgun legally in Texas. He contacts his former Texas licensed firearms instructor for guidance on whether his current Texas LTC is still valid for carrying in Texas. What is the most accurate advice Mr. Silas should receive regarding his Texas LTC? Option A. He can continue to carry in Texas under his Texas LTC, but must also obtain a new Texas LTC as a non-resident. Option B. He must immediately surrender his Texas LTC because he is now an Oklahoma resident. Option C. His Texas LTC is automatically invalid because he is no longer a Texas resident, and he must apply for an Oklahoma handgun license to carry in Texas. Option D. His Texas LTC remains valid for carrying a handgun in Texas as long as he complies with the terms of his Texas LTC and Texas law, even though he is now an Oklahoma resident. The correct answer is D. His Texas LTC remains valid for carrying a handgun in Texas as long as he complies with the terms of his Texas LTC and Texas law, even though he is now an Oklahoma resident. Explanation. Governance review demonstrates that a Texas resident, Mr. Silas, who holds a valid Texas license to carry a handgun, LTC, has recently moved to Oklahoma and is seeking to continue carrying a handgun legally in Texas while residing in Oklahoma. This scenario presents a professional challenge because it requires understanding the interplay between Texas's LTC requirements and the implications of establishing residency in another state, particularly concerning reciprocity and the validity of a Texas LTC for a non-resident. Careful judgment is required to ensure Mr. Silas understands his ongoing obligations and the limitations of his Texas LTC. The best professional approach involves advising Mr. Silas that his Texas LTC remains valid for carrying a handgun in Texas as long as he complies with the terms of his Texas LTC and Texas law, even though he is now an Oklahoma resident. This is because Texas law generally permits non-residents to obtain and maintain a Texas LTC, and the license itself does not automatically become invalid solely due to establishing residency in another state. The critical factor is adherence to the conditions under which the Texas LTC was issued and the laws of Texas. This approach prioritizes accurate information regarding the continued validity of the existing license and the governing laws. An incorrect approach would be to advise Mr. Silas that he must immediately surrender his Texas LTC because he is now an Oklahoma resident. This is incorrect because Texas law does not mandate the surrender of a Texas LTC upon establishing residency in another state. Such advice would be factually wrong and could lead Mr. Silas to believe he is no longer legally permitted to carry in Texas, which is not the case under these circumstances. Another incorrect approach would be to tell Mr. Silas that his Texas LTC is automatically invalid because he is no longer a Texas resident, and he must apply for an Oklahoma handgun license. While he may need an Oklahoma license to carry in Oklahoma, his Texas LTC's validity for carrying in Texas is not automatically terminated by his change of residency. This advice conflates the requirements for carrying in Texas with the requirements for carrying in his new state of residence. A further incorrect approach would be to suggest that Mr. Silas can continue to carry in Texas under his Texas LTC, but must also obtain a Texas LTC as a non-resident, implying he needs to reapply. This is incorrect because he already holds a valid Texas LTC. The process for non-residents to obtain a Texas LTC is distinct from the implications of an existing Texas LTC holder moving out of state. He does not need to reapply for a new Texas LTC if his current one is still valid, and he is complying with its terms. The professional reasoning process for such situations involves first identifying the core legal question: the continued validity of a Texas LTC for a former Texas resident now residing in another state. This requires consulting the specific provisions of the Texas Government Code pertaining to licenses to carry a handgun, particularly sections addressing non-resident licenses, and the grounds for revocation or suspension. The professional must then differentiate between the requirements for obtaining and maintaining a license in one's home state versus the implications of holding a license from another state while residing elsewhere. The focus should always be on providing accurate, jurisdiction-specific legal information and advising the client on their current legal standing and any necessary actions or considerations. Question 6. The audit findings indicate that a Texas resident who previously held a non-resident license to carry a handgun, but has since moved to Oklahoma and obtained an Oklahoma handgun license, has not actively renewed or confirmed the status of their Texas non-resident license for the past 3 years. The individual believed that since they no longer reside in Texas and have a valid license in their current state of residence, their Texas non-resident license would either automatically expire or become irrelevant. What is the most appropriate course of action for this individual to ensure compliance with Texas law regarding their former non-resident license to carry a handgun? Option A. Rely on the Oklahoma State Bureau of Investigation to provide information or guidance on maintaining the validity of their Texas non-resident license to carry a handgun. Option B. Immediately contact the Texas Department of Public Safety to inquire about the current status of their non-resident license to carry a handgun and follow any required procedures for renewal or cancellation to ensure compliance with Texas Government Code, Chapter 411, Subchapter H. Option C. Wait for a formal notification from the Texas Department of Public Safety regarding the status of their non-resident license to carry a handgun before taking any action. Option D. Assume the Texas non-resident license has automatically lapsed due to their change of residence and the acquisition of an Oklahoma license, and therefore no further action is required. The correct answer is B. Immediately contact the Texas Department of Public Safety to inquire about the current status of their non-resident license to carry a handgun and follow any required procedures for renewal or cancellation to ensure compliance with Texas Government Code, Chapter 411, Subchapter H. Explanation. The audit findings indicate a potential lapse in adherence to the Texas requirements for maintaining a non-resident license to carry a handgun. This scenario is professionally challenging because it requires an individual to proactively understand and comply with the specific legal obligations of holding a license issued by a state other than their primary residence. Failure to do so can have significant legal repercussions, including the revocation of the license and potential criminal penalties. The core issue revolves around the applicant's responsibility to ensure their out-of-state license remains valid and in good standing according to Texas law, even if their primary residence is elsewhere. The correct approach involves diligently verifying the current status of the Texas non-resident license to carry a handgun and understanding the renewal requirements as stipulated by the Texas Department of Public Safety, DPS. This includes being aware of any notification obligations or specific procedures for out-of-state licensees. The Texas Government Code, Chapter 411, Subchapter H, outlines the requirements for handgun licenses, including those for non-residents. Specifically, licensees are responsible for maintaining their eligibility and complying with all provisions of the law, which implicitly includes understanding and fulfilling renewal processes and notification requirements to the issuing state, even when residing in another state. This proactive verification ensures continued compliance with Texas law. An incorrect approach would be to assume that because the individual no longer resides in Texas, their obligations regarding the Texas non-resident license have ceased, or that the license automatically lapses without any action required on their part. This overlooks the fundamental principle that a license is granted under specific conditions and requires ongoing compliance with the issuing jurisdiction's laws. Another incorrect approach is to rely solely on the issuing state of their current residence for guidance on maintaining an out-of-state license, as each state's laws are independent. Finally, waiting for a direct notification from the Texas DPS about renewal or status changes without independently verifying the license's standing is also an unacceptable approach, as the onus is on the licensee to remain informed and compliant. Professionals facing similar situations should adopt a proactive and diligent approach. This involves understanding the specific requirements of any out-of-state licenses held, including renewal periods, address change notifications, and any other compliance obligations. Regularly consulting the official websites and regulations of the issuing state's licensing authority, in this case, the Texas DPS, is crucial. If there is any doubt about compliance, seeking clarification directly from the relevant authority or consulting with legal counsel specializing in firearms law is the most prudent course of action. Question 7. The control framework reveals that Mr. Henderson, a resident of Oklahoma, wishes to obtain a Texas license to carry a handgun. He holds a valid handgun license issued by the state of Oklahoma and frequently travels to Texas for business. He has contacted a Texas-based firearms instructor for guidance on the application process. What is the most appropriate course of action for the instructor to take? Option A. Advise Mr. Henderson that he must possess a valid handgun license from his home state of Oklahoma and confirm he meets all general eligibility requirements for a Texas non-resident license to carry a handgun as outlined in Texas Government Code Chapter 411, Subchapter H, including age and disqualifying factors, and that Oklahoma's license is recognized by Texas. Option B. Instruct Mr. Henderson to apply for Texas resident license, as he spends a significant amount of time in Texas for business, and that his Oklahoma license is sufficient for this purpose. Option C. Inform Mr. Henderson that since he holds a valid handgun license from Oklahoma, he automatically qualifies for a Texas non-resident license to carry a handgun, and can proceed with the application without further verification of Texas-specific requirements. Option D. Explain to Mr. Henderson that he only needs to meet the training and licensing requirements of Oklahoma, as Texas will honor any valid handgun license issued by another state without additional prerequisites. The correct answer is A. Advise Mr. Henderson that he must possess a valid handgun license from his home state of Oklahoma, and confirm he meets all general eligibility requirements for a Texas non-resident license to carry a handgun as outlined in Texas Government Code Chapter 411, Subchapter H, including age and disqualifying factors, and that Oklahoma's license is recognized by Texas. Explanation. The control framework reveals a scenario where a Texas resident, Mr. Henderson, is seeking to obtain a non-resident license to carry a handgun in Texas. The professional challenge lies in ensuring that Mr. Henderson meets all the specific statutory requirements for a non-resident license, which differ from those for Texas residents. This requires a thorough understanding of Texas Government Code Chapter 411, Subchapter H, and the reciprocity agreements Texas has with other states. Careful judgment is needed to avoid providing misinformation or facilitating an application that would be denied due to noncompliance with Texas law. The best professional practice involves accurately advising Mr. Henderson on the specific eligibility criteria for a Texas non-resident license to carry a handgun. This includes verifying that he possesses a valid handgun license from his home state of Oklahoma, which Texas recognizes through a reciprocity agreement. Furthermore, it requires confirming that he meets all other general eligibility requirements outlined in Texas Government Code Chapter 411, Subchapter H, such as being at least 21 years of age, not being disqualified by criminal history or other statutory prohibitions, and completing the required training. Providing this precise guidance ensures compliance with Texas law and facilitates a successful application. An incorrect approach would be to assume that because Oklahoma has a handgun license, Mr. Henderson automatically qualifies for a Texas non-resident license without verifying the specific terms of the reciprocity agreement and Oklahoma's own licensing requirements. This failure to confirm the validity and equivalence of his Oklahoma license and to ensure he meets all Texas-specific criteria could lead to an improper application and potential denial. Another incorrect approach would be to advise Mr. Henderson that he only needs to meet the requirements of his home state's license, ignoring the distinct Texas statutory obligations for non-residents. This overlooks the fact that Texas law dictates the terms under which it will issue a non-resident license, even if reciprocity exists. Finally, incorrectly advising him that he can apply for a Texas resident license simply because he spends significant time in Texas without meeting the residency requirements would be a clear violation of the law. Professional decision-making in such situations requires a systematic approach. First, identify the applicant's status, resident vs. non-resident. Second, consult the relevant Texas statutes and administrative rules governing handgun licenses for that specific status. Third, verify any applicable reciprocity agreements and their specific terms. Fourth, confirm that the applicant meets all general eligibility criteria. Finally, provide clear, accurate, and legally compliant advice based on this thorough review. Question 8. Cost-benefit analysis shows that providing accurate information on handgun carry reciprocity is crucial for licensed instructors in Texas. A client who holds a valid handgun license from a state other than Texas approaches you for guidance on whether their license is recognized for carrying a handgun within Texas. They are unsure if their home state has a formal reciprocity agreement with Texas and are seeking definitive advice. What is the most appropriate course of action to ensure compliance with Texas law and ethical professional conduct? Option A. Inform the client that since they possess a valid handgun license from another state, it is automatically recognized in Texas, as most states have reciprocal agreements for handgun carry. Option B. Advise the client that Texas recognizes handgun licenses from states with which it has a reciprocity agreement or has unilaterally recognized, and direct them to the official Texas Department of Public Safety, DPS, website and relevant statutes to verify the current status of their home state's license recognition and any associated requirements. Option C. Tell the client that they will need to apply for a new Texas license to carry a handgun regardless of their out-of-state license, as Texas does not recognize any out-of-state licenses for the purpose of carrying a handgun. Option D. Suggest that the client contact their home state's licensing authority to inquire about their handgun license's validity in Texas, as that authority would have the most up-to-date information. The correct answer is B. Advise the client that Texas recognizes handgun licenses from states with which it has a reciprocity agreement or has unilaterally recognized, and direct them to the official Texas Department of Public Safety, DPS, website and relevant statutes to verify the current status of their home state's license recognition and any associated requirements. Explanation. This scenario presents a professional challenge because it requires a licensed individual to navigate the complexities of interstate reciprocity for carrying a handgun, specifically concerning the Texas license to carry a handgun, LTC. The challenge lies in accurately interpreting and applying Texas statutes and administrative rules regarding the recognition of out-of-state permits, ensuring compliance with both Texas law and the laws of the applicant's home state, while also upholding ethical obligations to provide accurate information. Misinterpreting these regulations can lead to an applicant being misinformed about their legal rights and responsibilities, potentially resulting in legal consequences for the applicant and reputational damage for the instructor. The best professional approach involves a thorough understanding of Texas Government Code Chapter 411, Subchapter H, License to Carry a Handgun, and the relevant administrative rules promulgated by the Texas Department of Public Safety, DPS. Specifically, an instructor must be aware of the conditions under which Texas recognizes an out-of-state handgun license. This includes verifying if the applicant's home state has a reciprocity agreement with Texas, or if Texas has unilaterally recognized the applicant's permit based on statutory criteria. The instructor must then accurately communicate to the applicant the specific requirements for their situation, including any necessary steps to ensure their out-of-state license is recognized for carrying a handgun in Texas. This involves consulting the official DPS website and relevant legal statutes to confirm current reciprocity status and any specific endorsements or training requirements that might apply. An incorrect approach would be to assume that all out-of-state licenses are automatically recognized by Texas without verifying the specific reciprocity status. This failure to consult official sources and apply the specific statutory requirements of Texas law is a direct violation of the duty to provide accurate information and can lead to the applicant unknowingly violating Texas carry laws. Another incorrect approach would be to rely on outdated information or anecdotal evidence from other instructors or individuals. This demonstrates a lack of diligence and a disregard for the precise legal framework governing handgun carry in Texas, potentially leading to the dissemination of misinformation. Finally, providing a generalized answer without confirming the applicant's specific state of residence and its reciprocity status with Texas is also professionally unacceptable. This lack of specificity fails to address the applicant's unique circumstances and the nuances of Texas's recognition of out-of-state licenses. Professionals should employ a decision-making framework that prioritizes accuracy and adherence to legal statutes. This involves 1. Identifying the core legal question. How does Texas recognize out-of-state handgun licenses? 2. Consulting primary legal sources, Texas Government Code, Texas Administrative Code, and official Texas DPS publications. 3. Verifying reciprocity, checking the current list of states with reciprocity agreements and understanding the conditions for unilateral recognition. 4. Applying the law to the specific facts, determining how the applicant's home state's license status aligns with Texas requirements. 5. Communicating clearly and accurately, providing the applicant with precise information based on the verified legal status. Question 9. Which approach would be most professionally sound for a Texas resident applying for a non-resident license to carry a handgun in Texas, who has a prior misdemeanor conviction in another state that, if it occurred in Texas, will be classified as a Class B misdemeanor. Option A. Fully and accurately disclose the out-of-state misdemeanor conviction on the Texas LTC application, providing all requested details about the offense and the jurisdiction where it occurred. Option B. Assume the out-of-state misdemeanor conviction is automatically disqualifying and withdraw the application without disclosing it. Option C. Omit the out-of-state misdemeanor conviction from the application, assuming it is not relevant to Texas licensing requirements because it occurred in another state. Option D. Only disclose the out-of-state misdemeanor conviction if the application specifically asks for out-of-state criminal history. The correct answer is A. Fully and accurately disclose the out-of-state misdemeanor conviction on the Texas LTC application, providing all requested details about the offense and the jurisdiction where it occurred. Explanation. This scenario presents a professional challenge for a Texas resident applying for a non-resident license to carry a handgun, LTC, in Texas, who has a prior misdemeanor conviction in another state that, if it occurred in Texas, would be a disqualifying offense. The challenge lies in accurately disclosing this information and understanding its implications under Texas law, which requires applicants to be truthful and complete on their applications. Failure to disclose or misrepresenting information can lead to denial of the application, revocation of a license if granted, and potential criminal penalties. Careful judgment is required to navigate the disclosure requirements and understand how out-of-state offenses are evaluated. The best approach involves proactively and accurately disclosing the out-of-state misdemeanor conviction on the Texas LTC application, including all relevant details about the offense and the jurisdiction where it occurred. This approach is correct because Texas Government Code Section 411-174 mandates that an applicant for an LTC must provide truthful and complete information on the application. Furthermore, Texas Government Code Section 411-172 outlines the eligibility requirements, including that an applicant must not have been convicted of a felony or a Class or Class B misdemeanor. While the conviction occurred out of state, Texas law generally considers out-of-state offenses that would be equivalent to Texas disqualifying offenses. By disclosing the conviction, the applicant allows the Texas Department of Public Safety, DPS, to properly evaluate their eligibility based on the totality of the circumstances and applicable Texas statutes. This demonstrates honesty and compliance with the application process. An incorrect approach would be to omit the out-of-state misdemeanor conviction from the application, believing it is not relevant because it occurred in another state. This is a regulatory failure because Texas Government Code Section 411-174 explicitly requires disclosure of all criminal history, regardless of jurisdiction. The DPS is empowered to investigate and discover such information, and its omission constitutes a material misrepresentation, leading to application denial or license revocation. Another incorrect approach would be to only disclose the conviction if specifically asked about out-of-state offenses, rather than providing a complete criminal history as required by the application. This is a failure to meet the complete information requirement of Texas Government Code Section 411-174. The application is designed to elicit all potentially disqualifying information upfront, and selective disclosure is not permissible. A final incorrect approach would be to assume that an out-of-state misdemeanor conviction is automatically disqualifying, without understanding how Texas law interprets and applies out-of-state offenses. While it may be disqualifying, the applicant should disclose it and allow the DPS to make the determination based on Texas Government Code Section 411-172 and any relevant reciprocity agreements or interpretations. Attempting to self-disqualify or self-exempt without proper disclosure is a misstep. Professionals should adopt a decision-making framework that prioritizes transparency and full compliance with all application requirements. This involves carefully reading and understanding all questions on the application, researching Texas laws pertaining to LTC eligibility and disclosure of out-of-state offenses, and erring on the side of providing more information rather than less when in doubt. Consulting with legal counsel specializing in Texas firearm laws is also a prudent step when dealing with potentially disqualifying criminal history. Question 10. Investigation of the renewal process for a Texas non-resident license to carry a handgun requires precise financial calculation. If the Texas Government Code specifies a base renewal fee of $40 for such licenses, and there are no other statutorily mandated increases or administrative fees currently in effect as per the Texas Department of Public Safety's most recent publications. What is the total renewal fee a non-resident applicant must pay? Option A $40, Option B $36, Option C $44, Option D $50. The correct answer is A $40. Explanation: scenario analysis. This scenario presents a professional challenge in accurately calculating the required renewal fee for a Texas non-resident license to carry a handgun. The challenge lies in correctly interpreting the Texas government code regarding renewal fees, which can be subject to specific conditions and potential increases over time. Miscalculation can lead to the applicant being overcharged or undercharged, both of which have regulatory and ethical implications. Overcharging can be seen as unethical and potentially a violation of fee regulations, while undercharging could result in the license not being properly renewed, causing issues for the applicant and potentially the issuing authority. Careful judgment is required to ensure compliance with the Texas government code and to maintain professional integrity. Correct approach analysis. The best professional practice involves consulting the most current fee schedule as published by the Texas Department of Public Safety, DPS, or directly referencing the relevant section of the Texas Government Code that specifies the renewal fee for a non-resident license to carry a handgun. This approach ensures accuracy by relying on official, up-to-date information. The Texas Government Code, specifically Section 411(199)(a), outlines the renewal fee. As of the last legislative session, the renewal fee is $40. Therefore, calculating the renewal fee by taking the base renewal fee of $40 and adding any applicable statutory increases or administrative fees, if any are currently in effect and clearly defined by the DPS, is the correct method. For this question, assuming no additional statutory increases beyond the base fee are specified in the prompt's context, the calculation is simply the base renewal fee. Incorrect approaches analysis. One incorrect approach involves simply applying a fixed percentage increase to the initial application fee without consulting the specific renewal fee statute or current DPS fee schedule. This is problematic because renewal fees are often set independently of initial application fees and may not follow a proportional increase. Relying on a generic percentage increase ignores the specific legislative mandates for renewal fees in Texas. Another incorrect approach is to assume the renewal fee is the same as the initial application fee. This is a significant error because renewal fees are often different from initial application fees, and the Texas Government Code clearly distinguishes between them. The initial application fee is $40, but the renewal fee is also $40 as per the statute. But this is not always the case for all licenses and could be a point of confusion. The critical failure here is not adhering to the specific statutory provision for renewal fees. A third incorrect approach is to estimate the renewal fee based on common renewal fees in other states or general knowledge of licensing costs. This is fundamentally flawed as it completely disregards the specific legal framework governing handgun licenses in Texas. Each state has its own fee structure, and relying on external information is a direct violation of the principle of adhering to the specified jurisdiction's laws. Professional reasoning. Professionals must adopt a systematic approach to fee calculation. This involves 1. Identifying the specific license type and applicant status, e.g., non-resident. 2. Locating the governing statute or official fee schedule for that jurisdiction, Texas Government Code and Texas DPS. 3. Carefully reading and interpreting the relevant sections pertaining to renewal fees. 4. Performing the calculation based on the precise figures and any applicable statutory adjustments. 5. Verifying the calculation against official sources before communicating it to the applicant. This methodical process ensures accuracy, compliance, and ethical conduct. Question 11. Assessment of a Texas resident's eligibility for a non-resident license to carry a handgun in Texas, who has a prior misdemeanor conviction from another state, requires careful consideration of disclosure and disqualifying factors. Which of the following approaches best navigates this implementation challenge? Option A. Contact the Texas LTC instructor who provided the required handgun proficiency course for a definitive legal opinion on whether the out-of-state conviction disqualifies them. Option B. Disclose the prior misdemeanor conviction on the application, but proceed without verifying if it is a disqualifying offense under Texas law, assuming the DPS will make the determination. Option C. Fully disclose the prior misdemeanor conviction on the Texas LTC application. Research Texas Government Code, Chapter 411, Subchapter H for disqualifying offenses, and consult the Texas Department of Public Safety or legal counsel if eligibility is uncertain. Option D. Submit the Texas LTC application without mentioning the prior misdemeanor conviction, assuming it will not be discovered. The correct answer is C. Fully disclose the prior misdemeanor conviction on the Texas LTC application. Research Texas Government Code, Chapter 411, Subchapter H for disqualifying offenses, and consult the Texas Department of Public Safety or legal counsel if eligibility is uncertain. Explanation. Scenario analysis. This scenario presents a professional challenge for a Texas resident applying for a non-resident license to carry a handgun, LTC in Texas, who has a prior misdemeanor conviction in another state. The challenge lies in accurately disclosing this information and understanding its implications under Texas law, which requires a thorough and truthful application process. Failure to do so can lead to denial of the license and potential legal repercussions. Careful judgment is required to navigate the disclosure requirements and understand the disqualifying factors. Correct approach analysis. The best professional practice involves a proactive and transparent approach. This means the applicant should fully disclose the prior misdemeanor conviction on the Texas LTC application, providing all requested details. Furthermore, they should independently research Texas Government Code, Chapter 411, Subchapter H, which governs LTC eligibility, to understand if their specific conviction constitutes a disqualifying offense. If there is any doubt, seeking clarification from the Texas Department of Public Safety, DPS, or consulting with legal counsel specializing in Texas firearm laws before submitting the application is the most prudent step. This approach ensures compliance with the statutory requirement for truthful disclosure and demonstrates an understanding of the eligibility criteria, thereby minimizing the risk of application denial due to incomplete or inaccurate information. Incorrect approaches analysis. Submitting the application without disclosing the prior misdemeanor conviction is a direct violation of the statutory requirement for truthful disclosure on the LTC application. Texas Government Code, Section 411, 174A. 1. Mandates that an applicant must provide truthful information. Omitting this information constitutes a false statement, which can lead to denial of the license and potential criminal penalties. Disclosing the conviction, but assuming it is not disqualifying without verifying against Texas law, is also problematic. While disclosure is a step in the right direction, it does not absolve the applicant of the responsibility to ensure they meet all eligibility requirements as defined by Texas Government Code, Chapter 411. Subchapter H. Texas law outlines specific offenses that disqualify an applicant, and a conviction in another state can be treated similarly to a Texas conviction for these purposes. Contacting the Texas LTC instructor for a definitive legal opinion on eligibility based on an out-of-state conviction is an inappropriate approach. While instructors provide valuable training, they are not legal authorities empowered to make definitive legal determinations regarding an applicant's eligibility for an LTC, especially concerning out-of-state offenses. Such legal interpretations are the purview of the Texas DPS or the courts. Professional reasoning. Professionals facing similar situations should adopt a framework of diligent inquiry and absolute transparency. This involves 1. Thoroughly understanding all application requirements, including disclosure obligations. 2. Consulting the relevant statutes and regulations of the governing jurisdiction, in this case, Texas Government Code, Chapter 411, Subchapter H. 3. Seeking official clarification from the licensing authority, Texas DPS, or qualified legal counsel when ambiguity exists regarding eligibility or disclosure. 4. Prioritizing honesty and completeness in all interactions with regulatory bodies. Question 12. Market research demonstrates that a resident of Oklahoma who holds a valid handgun license issued by the state of Oklahoma is interested in obtaining a Texas non-resident license to carry a handgun. What is the most appropriate course of action for a Texas-licensed firearms instructor consulted by this individual? Option A. Recommend that the individual carry their handgun in Texas using their Oklahoma license. As most states recognize each other's permits, Option B. Inform the individual that holding a handgun license in any U.S. state automatically grants them the right to obtain a non-resident license in Texas. Option C. Advise the individual that Texas law requires a reciprocity agreement with their home state for a non-resident license to be issued, and if such an agreement exists, they must still meet all Texas eligibility requirements, including completing a certified handgun proficiency course and submitting a complete application to the Texas Department of Public Safety. Option D. Provide the individual with a Texas license to carry a handgun application form and instruct them to complete it, assuming their Oklahoma license will suffice for reciprocity. Correct answer is C. Advise the individual that Texas law requires a reciprocity agreement with their home state for a non-resident license to be issued, and if such an agreement exists, they must still meet all Texas eligibility requirements, including completing a certified handgun proficiency course and submitting a complete application to the Texas Department of Public Safety. Explanation: market research demonstrates that many Texans seeking to carry a handgun for self-defense are unaware of the specific requirements for obtaining a non-resident license, particularly concerning reciprocity with their home state. This scenario presents a professional challenge because a licensed instructor or firearms dealer, when consulted by a potential applicant, must provide accurate and compliant guidance. Misinformation can lead to an applicant unknowingly violating Texas law or the laws of their home state, potentially resulting in legal penalties or denial of their application. The core of the challenge lies in navigating the intersection of Texas statutes and the applicant's home state regulations to ensure a lawful and effective application process. The correct approach involves thoroughly understanding and applying Texas Government Code Chapter 411, Subchapter H, which governs the license to carry a handgun. Specifically, this approach requires verifying that the applicant's home state has a reciprocity agreement with Texas for handgun licenses. If such an agreement exists, the applicant must still meet all Texas eligibility requirements, including completing a certified handgun proficiency course and passing a background check. The instructor or dealer must then guide the applicant on how to submit their application to the Texas Department of Public Safety, DPS, emphasizing the need for accurate documentation from their home state that demonstrates their eligibility to carry a handgun there. This ensures compliance with Texas law, which allows for non-resident licenses based on established reciprocity, while also respecting the applicant's home state's authority. An incorrect approach would be to assume that simply having a handgun license in one's home state automatically qualifies an individual for a Texas non-resident license. This fails to acknowledge that Texas law requires a specific reciprocity agreement to be in place. Another incorrect approach is to provide the applicant with a Texas application form without first confirming the existence of reciprocity and ensuring the applicant meets all Texas eligibility criteria, potentially leading to wasted effort and a denied application. Furthermore, advising an applicant to carry a handgun in Texas based solely on their home state's permit, without verifying Texas's specific requirements for non-residents, is a direct violation of Texas law and a serious ethical lapse. Professional decision-making in such situations requires a commitment to accuracy and a proactive understanding of relevant statutes. Professionals should always consult the most current Texas Government Code and the Texas DPS website for information on reciprocity agreements and licensing requirements. When in doubt, it is always best to err on the side of caution and advise the applicant to seek official guidance from the Texas DPS or consult with legal counsel specializing in firearms law. The primary responsibility is to ensure the applicant can legally and safely exercise their rights. Question 13. Risk assessment procedures indicate that a Texas-licensed handgun instructor who is a resident of Oklahoma has received a renewal notice for their Oklahoma instructor certification. The instructor has not actively taught Texas LTC courses for over a year and is unsure if their Oklahoma certification is sufficient for renewing their Texas instructor status. What is the most prudent course of action to ensure continued compliance with Texas law for teaching license to carry a handgun courses to Texas residents? Option A. Continue teaching Texas LTC courses using their existing knowledge and Oklahoma certification until they receive a specific notification from Texas DPS indicating a problem. Option B. Proceed with renewing their Oklahoma instructor certification and then submit the Oklahoma renewal notice to the Texas DPS, expecting it to be automatically recognized. Option C. Assume that their current Oklahoma instructor certification is sufficient for renewing their Texas instructor status, as Oklahoma has similar firearm safety training standards. Option D. Contact the Texas Department of Public Safety, DPS, directly to inquire about the specific requirements for non-resident LTC instructors renewing their certification and confirm the validity of their Oklahoma certification for this purpose. Correct answer is D. Contact the Texas Department of Public Safety, DPS, directly to inquire about the specific requirements for non-resident LTC instructors renewing their certification and confirm the validity of their Oklahoma certification for this purpose. Explanation. Scenario analysis. This scenario presents a professional challenge for a Texas licensed handgun instructor who is also a resident of Oklahoma. The core issue revolves around maintaining compliance with Texas's specific requirements for non-resident license to carry LTC instructors, particularly concerning the renewal process and the potential for outdated information to affect training validity. The instructor must navigate the intersection of Texas's regulatory framework for LTC instructors and their personal residency status, ensuring that the training provided to Texans meets current Texas standards. Correct approach analysis. The best professional practice involves proactively verifying the current requirements for non-resident LTC instructors with the Texas Department of Public Safety, DPS, before initiating the renewal process. This approach ensures the instructor is operating with the most up-to-date information regarding eligibility, training materials, and any specific documentation or procedures mandated by Texas for non-residents seeking to renew their instructor status. The Texas Government Code, Chapter 411, Subchapter H, and associated administrative rules, specifically 37 Texas Administrative Code Section 6, 1 et sec, govern the LTC program, including instructor requirements. By directly contacting the Texas DPS, the instructor adheres to the principle of regulatory compliance, ensuring that the training they provide to Texas residents is valid and meets the state's safety and legal standards. This proactive step prevents potential issues arising from relying on outdated information or assuming that Oklahoma's instructor requirements are equivalent. Incorrect approaches analysis. Relying solely on the renewal notice from Oklahoma for instructor certification is professionally unacceptable because it fails to acknowledge that Texas has its own distinct licensing and instructor requirements. Texas law mandates that instructors meet specific criteria to train Texans for a Texas LTC, and these criteria may differ significantly from those in other states. Assuming that a valid instructor certification in one state automatically satisfies the requirements in another for the purpose of training residents of that other state is a regulatory failure. Furthermore, continuing to teach Texas LTC courses without confirming current Texas DPS requirements after a lapse in their Texas instructor status is a direct violation of the Texas Government Code, which requires instructors to be certified by the Texas DPS. This could lead to the invalidation of training provided, potential legal repercussions for the instructor, and a failure to uphold the safety and legal standards expected of LTC instructors in Texas. Professional reasoning. Professionals in regulated fields must prioritize direct engagement with the governing regulatory body for any jurisdiction in which they operate. When requirements change or when operating across state lines, a proactive approach to verifying current regulations is paramount. This involves consulting official government websites, contacting the relevant agencies directly, and ensuring all documentation and training practices align with the most recent legal mandates. The decision-making process should involve identifying the governing jurisdiction's laws, understanding personal obligations within that jurisdiction, and taking concrete steps to confirm compliance before undertaking regulated activities. Question 14. Market research demonstrates that individuals applying for a Texas non-resident license to carry a handgun often have questions regarding the validity of their out-of-state training. Considering the implementation challenges of navigating differing state regulations, which of the following approaches best ensures compliance with Texas law for a resident of Oklahoma seeking a Texas LTC? Option A. Submit an application based on the handgun training completed in Oklahoma, believing it is equivalent to Texas's requirements. Option B. Complete a handgun proficiency course that meets the specific requirements outlined by the Texas Department of Public Safety for non-resident applicants, and submit all required documentation, including fingerprints, to the Texas DPS. Option C. Rely on the fact that Texas recognizes handgun carry permits from all other states without requiring a separate application or training for non-residents. Option D. Assume that a valid handgun carry permit from Oklahoma automatically qualifies them for a Texas non-resident license to carry a handgun due to reciprocity. The correct answer is B. Complete a handgun proficiency course that meets the specific requirements outlined by the Texas Department of Public Safety for non-resident applicants, and submit all required documentation, including fingerprints, to the Texas DPS. Explanation: market research demonstrates that many individuals seeking a Texas non-resident license to carry a handgun, LTC, may not fully grasp the nuances of Texas law, particularly concerning reciprocity and the specific requirements for out-of-state applicants. This scenario is professionally challenging because it requires the applicant to navigate a complex legal framework that is distinct from their home state's regulations, demanding meticulous attention to detail and a thorough understanding of Texas Government Code Chapter 411, Subchapter H. Failure to comply can result in denial of the application, potential legal repercussions, and a loss of trust in the licensing process. The correct approach involves diligently reviewing and adhering to the specific requirements outlined by the Texas Department of Public Safety, DPS, for non-resident LTC applicants. This includes understanding that Texas law dictates the eligibility criteria, training requirements, and application procedures for all LTC holders, regardless of their state of residence. Specifically, a non-resident applicant must meet the eligibility requirements of Texas law, which includes completing a handgun proficiency course that meets Texas DPS standards, even if their home state has different or no such requirements. This approach is correct because it directly aligns with the statutory mandate of Texas Government Code Section 411-188, which specifies the requirements for non-resident licenses, and Section 411-1881, which mandates the completion of a handgun proficiency course. Adhering to these provisions ensures the applicant is meeting the legal obligations set forth by the state of Texas for carrying a handgun within its borders. An incorrect approach would be to assume that a valid LTC from another state automatically qualifies an individual for a Texas LTC without further action. This is a regulatory failure because Texas Government Code Section 411-172 outlines the general eligibility requirements for an LTC, and Section 411-188 explicitly states that non-residents must meet these requirements and complete a Texas-approved handgun proficiency course. Relying solely on an out-of-state license without meeting Texas's specific criteria is a violation of Texas law. Another incorrect approach would be to believe that Texas automatically recognizes all handgun carry permits from all other states without any specific application process or training verification. This is a significant regulatory failure, as Texas Government Code Section 411-173 allows for reciprocity agreements but does not grant automatic recognition of all permits. The DPS has specific procedures for non-residents, including the requirement to submit fingerprints and complete the mandated training, which are essential for a valid Texas LTC. A third incorrect approach would be to submit an application based on the training requirements of their home state, assuming they are equivalent to Texas's. This is a regulatory failure because Texas Government Code Section 411-1881 requires that the handgun proficiency course be taught by a qualified handgun instructor and cover specific material as determined by the Texas Commission on Law Enforcement Officer Standards and Education. Simply having completed a course in another state, even if it appears similar, does not guarantee it meets Texas's stringent standards. Professionals should approach such situations by prioritizing a thorough understanding of the specific jurisdictional requirements. This involves consulting official government resources, such as the Texas Department of Public Safety website, and carefully reading all application instructions and statutory provisions. When in doubt, seeking clarification from the relevant licensing authority is paramount. The decision-making process should be guided by a commitment to legal compliance and an understanding that each jurisdiction has its own unique set of rules that must be followed. Question 15. The risk matrix shows a moderate likelihood of a non-resident applicant for a Texas license to carry a handgun misunderstanding the specific requirements for out-of-state residents. An applicant from New Mexico, who has a valid New Mexico concealed handgun license, contacts you for guidance on obtaining a Texas LTC. They state they have a New Mexico driver's license and have lived in New Mexico for the past 5 years. What is the most appropriate initial step to ensure compliance with Texas law regarding non-resident LTC applications? Option A. Inform the applicant that Texas only recognizes licenses from states that border Texas and that New Mexico does not qualify. Option B. Recommend the applicant apply for a Texas LTC as a Texas resident, assuming their intent to move to Texas will be sufficient. Option C. Advise the applicant that since they possess a valid handgun license from another state, they are automatically eligible for a Texas LTC due to reciprocity. Option D. Verify that New Mexico has a current reciprocity agreement with Texas for license to carry a handgun, and confirm the applicant meets Texas's statutory definition of residency for non-resident applicants. The correct answer is D. Verify that New Mexico has a current reciprocity agreement with Texas for license to carry a handgun, and confirm the applicant meets Texas's statutory definition of residency for non-resident applicants. Explanation. The risk matrix shows a moderate likelihood of a non-resident applicant for a Texas license to carry a handgun, LTC, misunderstanding the specific requirements for out-of-state residents, particularly concerning reciprocity agreements and the definition of resident under Texas law. This scenario is professionally challenging because it requires a thorough understanding of Texas Government Code Chapter 411, Subchapter H, and the practical implications of its application to individuals who do not reside within the state. A critical judgment is needed to ensure compliance and avoid misrepresentation or providing incomplete information, which could have legal ramifications for both the applicant and the licensing entity. The correct approach involves meticulously verifying the applicant's residency status according to Texas legal definitions, and confirming that their home state has a valid reciprocity agreement with Texas for LTC purposes. This means not only checking if the applicant's state of residence is listed on the Texas Department of Public Safety's DPS reciprocity list, but also ensuring the applicant meets the residency criteria as defined by Texas law, which may differ from their home state's definition. This approach is correct because it directly adheres to the statutory requirements for non-resident LTC applications in Texas, prioritizing legal compliance and accurate information dissemination. It ensures that the applicant is eligible under Texas law and that their out-of-state license, if issued, is recognized through established reciprocity. An incorrect approach would be to assume that simply having a handgun license from another state automatically qualifies an applicant for Texas reciprocity. This fails to account for the specific residency requirements stipulated by Texas law, which may disqualify an individual even if their home state has a reciprocity agreement. Another incorrect approach is to rely solely on the applicant's self-declaration of residency without independent verification or understanding of Texas's legal definition of residency. This bypasses a crucial verification step mandated by the spirit and letter of the law. Finally, providing generalized information about reciprocity without confirming the specific status of the applicant's home state and their individual eligibility under Texas law is also an unacceptable failure. This can lead to the applicant pursuing an LTC under false pretenses or being denied later, causing frustration and potential legal issues. Professional decision-making in such situations requires a systematic process. First, identify the core legal requirements for the specific license type and applicant status, non-resident in this case. Second, consult the relevant statutes and official guidance, Texas Government Code Chapter 411, Subchapter H, and Texas DPS publications. Third, apply these legal standards to the specific facts of the applicant's situation, paying close attention to definitions and eligibility criteria. Fourth, communicate clearly and accurately, ensuring the applicant understands all requirements and potential outcomes. Question 16. Market research demonstrates a growing demand for Texas handgun licensing program instructors to offer specialized training for non-residents seeking to obtain a Texas license to carry a handgun, LTC. An instructor is approached by an individual who resides in Oklahoma and possesses a valid Oklahoma handgun license. The applicant states they have extensive experience with firearms and have completed a basic firearms safety course in their home state. What is the most appropriate course of action for the Texas instructor to ensure compliance with Texas Government Code Chapter 411, Subchapter H? Option A. Accept the applicant's Oklahoma handgun license as sufficient qualification and provide a general firearm safety refresher course without focusing on Texas-specific laws. Option B. Verify the applicant's Oklahoma handgun license is valid and confirm they meet the age and residency requirements for a Texas LTC. Then proceed with a Texas-specific LTC training course that covers Texas laws and use of force principles. Option C. Assume that possessing a handgun license from another state automatically qualifies the applicant for a Texas LTC and issue a certificate of completion based on their self-reported firearm experience. Option D. Focus solely on the applicant's stated extensive experience with firearms and provide a basic shooting proficiency test, deeming it equivalent to the required Texas LTC training. The correct answer is B. Verify the applicant's Oklahoma handgun license is valid and confirm they meet the age and residency requirements for a Texas LTC. Then proceed with a Texas-specific LTC training course that covers Texas laws and use of force principles. Explanation. Market research demonstrates a growing demand for Texas handgun licensing program instructors to offer specialized training for non-residents seeking to obtain a Texas license to carry a handgun, LTC. This scenario presents a professional challenge because instructors must navigate the specific requirements for non-resident applicants, ensuring compliance with Texas law while also considering the practicalities of training individuals who may not be familiar with Texas statutes. The instructor must balance providing comprehensive training with the legal mandate to certify eligibility under Texas Government Code Chapter 411, Subchapter H. The correct approach involves diligently verifying that all non-resident applicants meet the eligibility criteria as outlined in Texas Government Code Section 411, 187, which includes requirements related to residency in another state, age, and the absence of disqualifying factors. This approach is correct because it directly adheres to the statutory framework governing LTC eligibility for non-residents. The instructor must ensure the applicant possesses a valid handgun license from their state of residence or meets the criteria for obtaining a Texas LTC if they were a Texas resident, as per Texas Government Code Section 411, 172. Furthermore, the instructor must confirm the applicant has completed the required training course approved by the Texas Department of Public Safety, DPS, and that the applicant understands Texas laws pertaining to the carrying of handguns, as mandated by Texas Government Code Section 411, 188. This meticulous adherence to statutory requirements protects both the applicant and the instructor from potential legal repercussions and upholds the integrity of the licensing process. An incorrect approach would be to assume that an applicant's out-of-state driver's license or a general understanding of firearm safety is sufficient proof of eligibility for a Texas LTC. This fails to address the specific statutory requirements for non-residents, such as the need for a valid license from their home state or meeting Texas residency-based eligibility criteria if they were to apply as a Texas resident. Another incorrect approach is to solely rely on the applicant's self-certification of eligibility without any independent verification of their background or training completion, which bypasses the instructor's responsibility to ensure the applicant meets the legal qualifications. Finally, providing a generic handgun safety course without tailoring it to the specific legal requirements of carrying a handgun in Texas, including relevant statutes and use of force principles, would be inadequate and non-compliant with the spirit and letter of Texas Government Code Section 411, 188. Professional decision-making in such situations requires a systematic approach. First, thoroughly understand the specific statutory requirements for the target applicant group, in this case, non-residents seeking a Texas LTC. Second, develop a training and verification process that directly addresses each of these requirements. Third, maintain detailed records of all verifications and training provided. Finally, stay updated on any changes to Texas law or DPS regulations concerning LTCs for non-residents. Question 17. Process analysis reveals a Texas resident who currently holds a valid Texas license to carry a handgun, LTC, wishes to obtain an Oklahoma non-resident license to carry a handgun. What is the most appropriate and legally compliant course of action for this individual to pursue? Option A. Thoroughly research and complete Oklahoma's official application process for a non-resident license to carry a handgun, ensuring all required documentation, training verification, if applicable and different from Texas, and fees are submitted according to Oklahoma State Bureau of Investigation, OSBI, guidelines. Option B. Assume that because Oklahoma recognizes Texas LTCs for carry purposes, no separate Oklahoma permit is necessary, and continue to carry under their Texas LTC. Option C. Rely on general information about handgun reciprocity between Texas and Oklahoma, and submit a simplified application based on their existing Texas LTC without verifying current Oklahoma non-resident requirements. Option D. Contact the Texas Department of Public Safety for guidance on obtaining an Oklahoma permit, as they are the issuing authority for their current license. The correct answer is A. Thoroughly research and complete Oklahoma's official application process for a non-resident license to carry a handgun, ensuring all required documentation, training verification, if applicable and different from Texas, and fees are submitted according to Oklahoma State Bureau of Investigation, OSBI guidelines. Explanation. Scenario analysis. This scenario presents a challenge for a Texas resident applying for a non-resident license to carry a handgun, LTC, in Oklahoma. The core difficulty lies in navigating the reciprocity agreements and differing state requirements for handgun carry. A professional must ensure compliance with both Texas's existing licensing framework and Oklahoma's specific application process for non-residents, avoiding assumptions based solely on their Texas status. Misunderstanding or misrepresenting information can lead to application denial, potential legal repercussions, and damage to professional reputation. Correct approach analysis. The best professional approach involves meticulously researching Oklahoma's specific requirements for non-resident LTC applicants. This includes identifying the necessary application forms, required documentation, such as proof of residency in Texas, a valid Texas LTC, and potentially a fingerprint submission, any specific training prerequisites that differ from Texas, and the correct fee structure. It also necessitates understanding Oklahoma's reciprocity laws to confirm that a Texas LTC is recognized for carry purposes in Oklahoma, but critically, that the non-resident application process is still mandatory for obtaining an Oklahoma non-resident permit. This approach prioritizes accuracy, thoroughness, and direct adherence to the governing jurisdiction's regulations, ensuring a smooth and compliant application process. Incorrect approach is analysis. One incorrect approach is to assume that because Texas has an LTC and Oklahoma recognizes Texas LTCs for carry purposes, no separate application is needed for an Oklahoma non-resident permit. This fails to acknowledge that obtaining an Oklahoma non-resident permit is a distinct process with its own set of requirements, even if reciprocity exists for carrying. It bypasses the official application and vetting process mandated by Oklahoma for its non-resident permit holders. Another incorrect approach is to rely solely on general information about handgun reciprocity without verifying Oklahoma's specific non-resident application procedures. This might lead to submitting an incomplete or incorrect application, or attempting to carry under the Texas license without the proper Oklahoma non-resident permit, which could be a violation of Oklahoma law. A third incorrect approach is to submit an application based on outdated information or assumptions about previous reciprocity agreements. State laws and application requirements can change, and failing to consult the most current official guidelines from the Oklahoma State Bureau of Investigation (OSBI) or its designated authority can result in significant errors and application rejection. Professional reasoning. Professionals should adopt a systematic approach to cross-jurisdictional licensing. This involves 1. Identifying the target jurisdiction and the specific license or permit required. 2. Thoroughly researching the official statutes, regulations, and application procedures of that jurisdiction. 3. Consulting official government websites and contact points for clarification. 4. Ensuring all documentation is accurate, complete, and meets the specific requirements of the target jurisdiction. 5. Understanding the implications of reciprocity agreements, but not relying on them as a substitute for required applications. Question 18. The efficiency study reveals a recurring challenge in processing non-resident license to carry a handgun applications in Texas. Inconsistent verification of out-of-state training. A Texas Department of Public Safety, DPS, licensing specialist is reviewing an application from a resident of New Mexico who has submitted a certificate for a handgun proficiency course completed in their home state. What is the most appropriate course of action for the licensing specialist to ensure compliance with Texas regulations? Option A. Reject the application outright, stating that only Texas-approved handgun proficiency courses are acceptable for a Texas license to carry a handgun. Option B. Accept the New Mexico training certificate without further inquiry, assuming it meets Texas standards due to interstate reciprocity. Option C. Request detailed documentation from the applicant or the New Mexico training provider that clearly outlines the curriculum, duration, and specific topics covered in the handgun proficiency course to verify its equivalency to Texas requirements. Option D. Contact the New Mexico DPS to inquire about their general handgun training standards without requesting specific details about the applicant's course. The correct answer is C. Request detailed documentation from the applicant or the New Mexico training provider that clearly outlines the curriculum, duration, and specific topics covered in the handgun proficiency course to verify its equivalency to Texas requirements. Explanation. The efficiency study reveals a recurring challenge in processing non-resident license to carry a handgun applications in Texas. Inconsistent verification of out-of-state training. This scenario is professionally challenging because it requires balancing the applicant's right to obtain a license with the state's obligation to ensure public safety through adherence to strict training requirements. Misinterpreting or inadequately verifying out-of-state training can lead to the issuance of licenses to individuals who may not meet Texas's safety standards, or conversely, unjustly denying licenses to qualified applicants. Careful judgment is required to navigate the nuances of interstate reciprocity and training equivalency. The best professional practice involves meticulously comparing the applicant's out-of-state training certificate against the Texas requirements for license to carry a handgun proficiency. This approach necessitates a thorough understanding of Texas Government Code Chapter 411, Subchapter H, which outlines the specific curriculum and duration of handgun proficiency courses required for a Texas license. When an out-of-state certificate is presented, the responsible party must actively seek to confirm that the training received by the applicant meets or exceeds the Texas standards, potentially by contacting the issuing authority in the applicant's home state or by requiring supplementary documentation that clearly delineates the course content and hours. This proactive verification ensures compliance with Texas law, which mandates that out-of-state training must be equivalent to Texas-approved courses. An incorrect approach would be to accept an out-of-state training certificate at face value without any independent verification of its equivalency to Texas standards. This fails to uphold the regulatory requirement that out-of-state training must be substantially similar to Texas-approved courses, potentially leading to the issuance of licenses to individuals who have not received adequate safety and legal instruction. Another incorrect approach is to automatically reject any out-of-state training certificate, regardless of its content, based on a blanket assumption of non-equivalency. This is overly restrictive and fails to acknowledge the reciprocity provisions that allow for recognition of equivalent training, thereby unfairly penalizing qualified applicants. A third incorrect approach involves making a subjective judgment about the quality of the out-of-state training without a clear, objective standard for comparison, which introduces an unacceptable level of arbitrariness and potential for bias. Professionals should employ a decision-making framework that prioritizes regulatory compliance and applicant fairness. This involves establishing clear internal protocols for evaluating out-of-state training, including a checklist of essential course components and hours. When faced with an unfamiliar out-of-state certificate, the process should involve seeking clarification from the applicant and, if necessary, from the relevant authorities in the applicant's home state to confirm equivalency. This systematic and verifiable approach minimizes errors and ensures that decisions are based on objective evidence and adherence to Texas law. Question 19. What factors determine the validity of an applicant's claim for a Texas license to carry a handgun as a non-resident, and what documentation is crucial for an instructor to verify this status in Texas? Option A. The applicant's sworn statement of out-of-state residency, coupled with a valid, unexpired driver's license or state-issued identification card from their home state. Option B. The applicant's intention to visit Texas frequently, even if their primary residence is within Texas. Option C. The applicant's assertion of living out of state, regardless of supporting documentation, as long as they have completed the required training. Option D. The applicant's possession of a firearm that is legal to own in Texas, irrespective of their residency status. The correct answer is A. The applicant's sworn statement of out-of-state residency, coupled with a valid, unexpired driver's license or state-issued identification card from their home state. Explanation. This scenario presents a professional challenge because it requires a Texas license to carry, LTC instructor to navigate the complexities of out-of-state residency and its implications for issuing a Texas LTC, while also upholding the integrity of the licensing process and adhering strictly to Texas law. The instructor must balance the applicant's desire for a Texas LTC with the legal requirements that govern who can obtain one, particularly concerning their primary residence. The correct approach involves meticulously verifying the applicant's documentation to confirm their primary residence is indeed outside of Texas, as required for a non-resident application. This means the instructor must ensure the applicant provides acceptable proof of their out-of-state domicile, such as a valid driver's license from another state, utility bills, or voter registration from their home state. This approach is correct because Texas Government Code Section 411, 173, A and Section 411, 173, B explicitly outline the eligibility requirements for a Texas LTC, including that an applicant must be a legal resident of Texas or a legal resident of another state. For non-residents, the law requires proof of their out-of-state residency. By strictly adhering to these statutory requirements and verifying the applicant's out-of-state primary residence, the instructor fulfills their legal obligation and ensures the integrity of the Texas LTC program. An incorrect approach would be to issue the Texas LTC based solely on the applicant's assertion that they live out of state, without demanding or thoroughly reviewing documentation that substantiates this claim. This fails to meet the statutory requirement of proving out-of-state residency, potentially leading to the issuance of a license to someone who does not meet the legal criteria. Another incorrect approach would be to deny the application outright because the applicant is not a Texas resident, without considering the provisions for non-resident licenses. This ignores Texas Government Code Section 411, 173, B, which specifically allows for non-residents to obtain a Texas LTC if they meet certain criteria, including proving their out-of-state domicile. Finally, accepting documentation that clearly indicates a Texas address as proof of out-of-state residency would be a severe regulatory failure, as it directly contradicts the applicant's claimed residency and the legal requirements for a non-resident license. Professional decision-making in such situations requires a thorough understanding of the relevant Texas statutes governing LTC eligibility, particularly the distinctions between resident and non-resident applicants. Instructors must prioritize adherence to the law, employ due diligence in verifying all submitted documentation, and maintain a commitment to the integrity of the licensing process. When in doubt about the validity of documentation or an applicant's eligibility, instructors should err on the side of caution and seek clarification or consult with the Texas Department of Public Safety. Question 20. Compliance review shows that a Texas license to carry a handgun, LTC applicant, who is a resident of Oklahoma, has submitted an application through your agency. The standard non-resident LTC application fee in Texas is $100. The Texas Department of Public Safety, DPS, also assesses a federal background check surcharge of $15 for all non-resident applicants. If the applicant paid a total of $100 for their application, what is the most appropriate course of action for the licensee to take? Option A. Inform the applicant that the total fee is $100 and proceed with submitting the application as is. Option B. Submit the application with the $100 payment, assuming the federal background check surcharge might be waived or absorbed by the agency. Option C. Inform the applicant that the payment is insufficient and request the remaining $15 to cover the federal background check surcharge, ensuring the application is submitted with the correct total fee of $115. Option D. Inform the applicant that the total fee is $100 and advise them to separately pay the federal background check surcharge directly to the Texas DPS. The correct answer is C. Inform the applicant that the payment is insufficient and request the remaining $15 to cover the federal background check surcharge, ensuring the application is submitted with the correct total fee of $115. Explanation: this scenario presents a professional challenge because it requires a licensee to accurately calculate and report fees, demonstrating a thorough understanding of Texas fee structures and potential surcharges. Miscalculations can lead to financial discrepancies, potential penalties for the applicant, and damage to the licensee's professional reputation and compliance standing with the Texas Department of Public Safety, DPS. Careful judgment is required to ensure all applicable fees are accounted for and correctly applied. The correct approach involves meticulously calculating the total fee based on the standard non-resident license fee and any applicable federal background check surcharges, as outlined by Texas law. This approach is correct because it directly adheres to the statutory fee requirements for a Texas license to carry a handgun, LTC, for non-residents. The Texas Government Code, specifically Section 411-184, details the fees associated with LTC applications, including provisions for non-resident applicants. By calculating the base fee and adding the specific federal background check surcharge, the licensee ensures full compliance with the established fee schedule, preventing undercharging or overcharging the applicant. An incorrect approach would be to only charge the base non-resident license fee without accounting for the federal background check surcharge. This is a regulatory failure because it omits a mandatory fee component required by Texas law for non-resident applicants, potentially leading to an incomplete application submission and subsequent rejection by the DPS. Another incorrect approach would be to estimate the total fee based on a general understanding of licensing costs without consulting the specific Texas DPS fee schedule. This is an ethical and regulatory failure as it relies on guesswork rather than precise legal requirements, risking financial inaccuracies and noncompliance with the established fee structure. A further incorrect approach would be to charge a flat fee that includes an arbitrary amount for the federal background check, not based on the actual surcharge. This is a regulatory and ethical failure because it deviates from the statutorily defined fee, potentially overcharging the applicant and violating the principle of transparent and accurate fee collection. Professionals should employ a decision-making framework that prioritizes consulting official regulatory documents, such as the Texas Government Code and the Texas DPS website for the most current fee schedules. They should then perform precise calculations using the provided figures, ensuring all mandatory components are included. If there is any ambiguity, seeking clarification from the Texas DPS directly is the most responsible course of action before submitting any application or collecting fees.